dust is yet to settle over the Imo State governorship election judgment by the Supreme Court. The Supreme Court, we understand, is expected to sit on the review of the judgment as requested and petitioned by the PDP and Mr. Emeka Ihedioha. What does this mean anyways? Let's discuss this, everyone. Joining me here in the studio is a lawyer. We shall be doing some legal gymnastics of some sort because I have two lawyers who are not agreeing on the particular matter that we're discussing tonight. They might be friends, but they disagree. Mr. Evans Ufeli is a lawyer who practices here in Lagos. Thank you so much for coming on tonight.
Thank you. Good evening.
And tonight we have Mr. Daniel Buala from our Abuja studio. He's also a lawyer. But tonight, both of them may not agree on what we're discussing. Thank you so much, everyone, for joining us, gentlemen. You are one of the civil society organizations today. You belong to a civil society organization that did a press conference today and said the Supreme Court's decision in the case of Imo governorship election is wrong. Why?
Yes. Yeah, because if you look at the Constitution to start with, the Constitution is a grand norm. I mean, it is upon the provisions of the Constitution that every law and every person's rests. Okay, Section 179, subsection 2B of the 1999 Constitution stated, I've stated expressly the requirements upon which a person can become the governor of a state. And that is that you must have 25% of the total vote cast in at least 2/3 of the local governments. Now, if you look at both parties, Emeka Ihedioha and then Senator Hope Uzodinma, you find out that first, Ihedioha was declared the governor, that is by INEC. And then we look at the number of votes scored, the percentage vis-a-vis the Constitution. You discover that he scored 25% in 14 local governments. And we know the total in Imo State 27 local government. That is not up to the required position. Now,
that's your calculation?
Yes. No, it's the results are before INEC. Now, we challenge INEC to bring the results that they are not true. I mean, that is in public place.
Let's apologies, please. We'll take a breather. When we come back, we'll look at some of these arguments and some of the figures that are being brought forward. On our Did You See That segment, what is perhaps not meant to be? The case of Mr. David Lyon, who was sacked by the Supreme Court hours before his inauguration as governor of Bayelsa State. And before the court's decision came, Mr. Lyon was attending a dress rehearsal for his inauguration, scheduled for the following day at the Samson Siasia Sports Stadium in Yenagoa, the state capital. The 11th hour drama, which changed things 360 degrees. There's a lot of contestation over so many of the judgments. There is Zamfara, there is Bayelsa, there is Imo State, and a lot of people are already quoting a section of the law. What does the law say? Let me show you what the Nigerian Constitution says about if you are to become a governor in Nigeria, what are you required? So look at it. It's section 179 of the section of the Constitution, subsection 2, clearly said, and let's take a read together. A candidate for an election to the office of a governor of a state shall be deemed to have been duly elected where there being two or more candidates. A, he has the highest number of votes cast at the election, and he has not less than 1/4 of all the votes cast in each of at least 2/3 of all the local government areas in the state. I've broken it down for you to understand. In the case of Imo State, take a look at it. There are 27 local government areas in Imo State. The 2/3, mathematically speaking, will be 18 of the 27. Look at it. So the spread of it will be 25% of the votes cast in 2/3. 2/3 of 27 is 18. Let's get back to the conversation. Mr. Evans Ufeli, a lawyer here in Lagos, and from Abuja is Mr. Daniel Buala, also a lawyer. Thank you so much, gentlemen, for coming on tonight. So you're saying that Mr. Ihedioha did not have the spread.
Yes, did not have the constitutional
What
requirement
about Mr. Uzodinma?
as regards the spread. Mr. Hope Uzodinma also did not have the spread as required by law. And one thing we must understand is that the Supreme Court is a creation of the Constitution of the Federal Republic of Nigeria. That is one. Two, the office of the governor is a creation of the Supreme Court of Nigeria. It therefore means that the Supreme Court of Nigeria cannot create precedents outside the Constitution. Because what that does is that every other inferior court will have to feed from that. So if the Supreme Court is not getting it right, it means we are laying down a dangerous precedent that we cannot feed in future.
So what is it that the Supreme Court did not get right? In the case
Because both parties did not get the constitutional requirements. So there's supposed to be a rerun.
So you are saying that there should be a rerun?
There should be a rerun because now they are doing a review, right? They are doing a review now. And part of the review should be a consideration for a rerun because both parties did not clinch it. I mean, if you look at Senator Hope Uzodinma's results, he won, he got 25% in just 2 local governments. And you declared him the governor of the state. How do you sustain that in the fledgling democracy? How? Those are questions we must ask. And we must find answers to this question as it relates to our political development. Because if you look at it...
So you're saying Supreme Court made a mistake?
They erred.
No, but...
The Supreme Court, the fact that they are Supreme Court does not mean they cannot err. If you look at the case of Johnson versus Lawanson in 1971, the Supreme Court erred. And the Supreme Court also took time out to look at the judgment again. And then they did the needful. Because they are humans. So let's...
Was there a reversal in that 1971?
There was a review.
Okay, after the review,
there was a review, and then the Supreme Court now lay the procedures and lay down the bricks upon which where they have erred by virtue of a typographical error or whether the judgment was obtained by fraud or whether there's a part of facts or law they ought to have considered they did not consider. If you look at it now, the Supreme Court ought to have considered the spread. They did not consider that. If you look at the Electoral Act, the Electoral Act talks about the issue of the margin of lead. By the time you add Hope Uzodinma's vote together and vis-a-vis that of Emeka Ighodioga, we are finding an issue of the spread in the terms of the margin of lead. Then Section 26 of the Electoral Act should apply. We have a lot of issues of law, okay, that were not considered. And when these things are found, we must look at it again, vis-a-vis what is it that the Supreme Court ought to have done that they did not do. And that is the essence of this review. Right. And this review is not a sin. It's just to look at the laws again and then reconsider the position and then make the necessary adjustment for the purposes of posterity and precedent. It is critical.
It was actually a unanimous judgment. That means that there was no dissent in that judgment. All the judges on the bench on that day agreed and they were on one position.
Yes, it was a unanimous judgment, but that does not mean that it was a sound judgment or it was a right judgment. I mean, if you have a unanimous judgment that did not consider the constitutional requirements, what kind of judgment are you talking about? The constitutional requirement is fundamental. The Constitution is fundamental. I mean, it is a ground norm. Except the Supreme Court want to tell us that this Constitution is no longer the ground norm. Then we can take that position. But if this Constitution is the ground norm, then I think that the review must consider issues of law that were not considered in this judgment.
When I was speaking, when we're trying to find a way of tackling this issue, and I was sounding lawyers off, I understand, I got that Mr. Boala does not agree with what your position is. Mr. Boala, do you agree that there was an error in the judgment of the Supreme Court on the Imo case?
If it is in the case of David Lyon, yes, there was error. But in the case of Hope Uzodinma, there is none. I'm happy that the lawyer in your studio stated some of the facts, some of the conditions for review when he talks about the law. Because one of the salient and basic conditions for asking the court, especially Supreme Court, to review its decision and depart from the previous decision is if you can show that the Supreme Court has reached the previous decision per incurium. Now, per incurium has been defined in plethora of authorities of even the Supreme Court, the Supreme Court, that it is drawn from the Latin word through inadvertence, through ignorance. And inadvertence and ignorance as found in that per incurium must relate to law, statutes, principles of law, which the Supreme Court did not avert its mind to when it was giving the decision, which if the Supreme Court had considered at the time it was delivering the decision, the Supreme Court would not have arrived at the point they arrived at. So that argument that they are giving actually applies to David Lyon's case, because when the Supreme Court was giving the judgment in David Lyon's case, they did not avert their mind to section 140 sub 2 of the Electoral Act, which states that if you nullify an election on the ground that somebody is disqualified, you shall not declare the person who scores the second highest vote as a winner, but you shall order a fresh election. So that is the law, statute, construction, instrument. The Supreme Court did not avert its mind. So David Lyon can come to court and ask for a review. But if you look at the what we call the grounds of appeal of whoever is coming to court and asking for review, and if what you find in your grounds are litany of facts, like the way the lawyer is talking about, this number minus this person didn't meet the required spread, there was election, there was no, these are statement of facts. The question you will ask yourself is, were these matters dealt with at the tribunal and court of appeal? If the answer is in the affirmative, then bringing it up to the Supreme Court will mean you're asking the Supreme Court to re-litigate the matter, for which it will be considered as the abuse of court process, because matters that was comprehensively dealt with cannot be brought back to the court. Doing so will offend the court. But if in the course of delivering judgment, the court forgot a fundamental statute or instrument of law, which it has averted its mind to it, the court will not have arrived at that. That would be a good ground. Now let's come to the issue of the judgment that was delivered in Hope Uzodimma's case. At the trial court, Hope Uzodimma approached the court and said, the election was free and fair. I agree to it. The problem I have is that in this number of polling units, I have scored some votes which was excluded. These are pleadings. Parties agree based on pleadings. They join issues. The camp of EADU said, no, you didn't score that. Now, in our principle of law, facts that are not traversed, facts that are not denied, are deemed to have been admitted. And if they are admitted, they require no further proof. Now, and if you are traversing a fact, if you are contending a fact, you must also establish the genuineness of the item you are contending, or in order to avoid this principle of regularity. Now, when Hope Uzodimma presented the so-called results in the various polling units, the opportunity was there for Ihedioha to counter it by presenting what he believes to be the original result. He did not do that. Secondly, he alleged that Hope Uzodimma forged or faked those results. That is an allegation of crime. It's criminal. And the Electoral Act is clear that you have to prove that beyond reasonable doubt. That EADU have failed to do it. And the proof beyond reasonable doubt is not just by assertion. It is by tendering the genuine document that you are contending the one the other party has. They failed to do it. INEC, which is the unbiased umpire, that had the opportunity to come between them and say, this is the original result. INEC failed to do that. Hope Uzodimma was able to present the result of police. Now, EADO have contended that that result that you are tending cannot be accepted in law because it is the police officer that should come and tender it and not the agent of Hope Uzodimma. The court looked at it, especially the Supreme Court, and looked at the document that the police officer gives and cited some decision of the Supreme Court to show the regularity of those documents. Fundamentally, that was where the matter was decided. You have failed to debunk, you have failed to disprove the results that Hope Uzodimma presented. You happen to find a judgment. You then go into Court of Appeal. And then the matter came to Supreme Court. Supreme Court delved into what you guys joined issues with and comprehensively arrive at a conclusion that you have failed to disprove the result. So the Supreme Court accepted the result, and did the computation, which led to the arrival that Hope Uzodimma had the highest vote. This is not sentiment. This is not I belong to a political party. Any lawyer listening tonight knows in law, facts that are not disproved, they are deemed admitted. And however bad that fact is, if you fail to appeal to disprove it, the court cannot come from heaven and do your case. That's why you hear this age-long principle that the court is not a Father Christmas and the court cannot delve into the matter. So if somebody, assuming now, is coming for a review, all we need to do is to look at your grounds of appeal. Are you talking about a particular instrument of law that when the Supreme Court was giving decision, it forgot? But if you started mentioning all of those facts, you sure know
All right,
the end of the
Mr.
matter.
Boala,
That you can
Mr.
never
Boala,
succeed because
Mr.
doing
Boala.
so, it means you are relitigating the matter.
I'd like to ask you two quick questions so that we can lay some facts on the table, and I'll allow Mr. Ofeli to respond to you. These two quick questions are that, first and foremost, have you read the judgment of the Supreme Court in the case of Mr. Ihedia and Opus Odema? Have you read it?
Yes, I have. I have
Okay.
read the late judgment.
Have you looked at the fact that after the addition of the figures which the Supreme Court gave, if my producer, some of the figures that came out, are you aware that perhaps some of the figures are more than the registered voters afterwards, and in fact, more than the votes cast in some areas in the election? Are you aware also?
First of all, I'm not aware, but even if those exist, these are issues of facts. So the Ihedioha must contend it and establish it. He cannot assume or expect the Supreme Court to do the job for him. That is one thing about law. If you fail to prove your case, don't go there, going to American embassy and US and everywhere cannot solve the issue. Look into the judgment and look into your case. Did you contend at the time that, you see, there is in law shown what we call argument in the alternative? That you will say, if the court believes and arrives at a decision that Opus Odema scored this, we are still objecting that computation of this result will suggest that the number of the vote he has won or the total number of votes declared by the court is more than the registered voters. It is Ihedioha that is supposed to speak. It is not the court that will come down and speak for him. But if it is a matter of law, the court, they said in the breast of the judge lies the fountain of justice. If it is a matter of law, the court in arriving at that decision will then have to consider.
All right, then let me ask you another quick one. Let me ask you another quick one. In the case of the section 179 of the Constitution, 1999 Constitution as amended, the provision of the spread, do you think that a governor should be without having the spread, which is constitutional? This is not the Electoral Act. This is a provision of the Constitution.
The constitutional provision for one scoring the highest lawful vote and meeting the required is sacrosanct and a ground on which somebody will be declared as a winner. And Diri in Bayelsa did not meet the second part. And INEC operated as a medusum interloper to assume the position of judiciary in interpreting it. That one does not apply in Opus Odema's case. Okay, and in fact, the principle of law is that the judgment of the Supreme Court is final, not because it is infallible, but it is infallible because it is final.
So, okay, so you are saying that the Supreme Court, there is no possibility of the Supreme Court reviewing the case. Perhaps a day after the judgment, they discover that they made a mistake.
A day after delivering the judgment? Supreme Court is not a supermarket. Supreme Court is a court that sits, parties aggrieved approach it, and there is a procedure. So the grounds on which Supreme Court can review itself is if there are clerical error in the judgment, then the Supreme Court can go ahead to correct that. But without that, the condition that is outlined by law for having the court review the matter is sacrosanct. As per discussing the merit or demerit of the application in the Supreme Court, by our discipline of law, we don't delve into substantive matter that is right there in the court.
All right,
but
let me allow Mr. Ofeli,
Mr. Of law for a party who wants to
just a moment. Let me allow Mr. Ofeli to weigh in. Do you agree with the position of Mr. Boala?
No, I don't agree with his position because he has just taken us aback through the process of the election and then the tribunal, the court of appeal. Okay, but what we are saying is that even if you add those votes from the 388 local government, 388 polling units to that of Senator Hope Uzodinma, he still did not meet the spread. And that is a constitutional requirement. So are you going to have a governor that did not meet the required constitutional provision? And if you lay that down as a precedent, what it means is that tomorrow I can contest for the position of a governor and then go somewhere, or my local government somewhere, and then bring up issues, and then I will be declared governor without the spread.
But
So
he
we need to.
has made some valid, that in the courtroom, some, well, did I say valid? He made some position here, his argument rather, that in the courtroom, the argument of the court, of the lawyers matter with what the Supreme Court will give as a judgment. Since the Supreme Court is not a Father Christmas.
Yes, it matters. It's fundamental.
Do you think that the Supreme Court would have given a judgment outside the argument that was laid before it?
No, it's not even outside the argument. We are talking about statute now. We are talking about provisions of constitution, which you and I know, which you read just at the beginning of the program. And then you have two candidates who did not meet the requirements. It's that simple. So what are you supposed to do in that case? If you do not meet the requirement, then there will be a rerun and not declare someone who just had 25% in two local governments. And then you made him a governor. So how are you going to feed that kind of precedent in the future? It's not for today. It's for the future. This is a democracy that it's a hard-earned democracy that we must protect. And if we must protect it, then we must put in everything to make sure that we do the right thing at all times. So that these precedents will be, because if you look at, the international communities now are weighing in, and then you see how embarrassing it is. Let's do the right thing. Let's go back to the polls and then do the right thing. Declare who gets the constitutional requirement as governor. That is what we are saying.
Some of the other issues, quickly, before I go back to Abuja with Mr. Abuala, he mentioned on the fact that we find the Constitution is sacred, but the fact that the Supreme Court knows that it is fallible, but it makes a decision because of certain reasons. In the case of the Supreme Court, if it does review its judgment on Tuesday, and you're saying going back to the drawing board is the case, so it will be between Mr. Ihedioha and Uzodinma should the Supreme Court make that decision. Is that what you're saying?
Yes.
So it will be a by-election?
Well, it will be a rerun.
A rerun?
A rerun. A rerun, because if you look at it, even the result that we're talking about, that he's talked about, okay, that Hope Uzodinma brought through the policeman and all that. You see, he'd understand the doctrine of proper custody by the Evidence Act, Section 146 or thereabout of the Evidence Act. In whose custody naturally should you have an INEC result, for example? Okay, proper custody. I don't want to go into the jurisprudence of the authenticity or not of that result, since the Supreme Court has already accepted it. But what we're saying is that now that result runs contrary to what INEC even have as regards number of vote, cast and the number of registered voters. So if you look at all these are the technical issues that were discussed in Lawanson, Johnson against Lawanson in 1971, okay, upon which they went back to the drawing board. And now, almost how many years later, we can still do the same thing because that is the precedent. And that is, I still believe that by the time they get into the review, they will come across all these discrepancies.
But have you studied the petition of the PDP and Ihedioha to the Supreme
application.
Court? The application.
The application, yeah. I've seen the application. I've also read the judgment vis-a-vis all the contestation. I've seen that, you see, the position that I'm canvassing tonight is you cannot become a governor without the spread. If it is the Electoral Act that is saying that you are looking at to reach that decision, then perhaps we can forgive your trespasses. But if it's the Constitution that has made a provision, this Constitution is supreme. And this provision shall have a binding force on all persons and authority throughout the Federal Republic of Nigeria, including the Supreme Court.
This is not the only Supreme Court judgment on a governorship election after 2019. Is Imo governorship case a departure from all of the ones that we have seen?
Yes.
Is it the only one?
It's a complete departure, because if you look at it, before now, it is very difficult for you to get into this kind of argument and then upturn. Most of the judgment we had are pre-election matters upon which you have a lot of issues to contest with. But in this particular judgment is a complete departure from, I mean, look at the fact of the case, okay? Look at the fact of the case, 388 polling units, and then that result was presented by someone other than INEC. The argument is that it's a duplicate copy. So is the evidence act no longer relevant?
All right, let's get Mr. Buala. Mr. Buala, react to some of the issues raised by Mr. Ofeli.
Well, the only thing I can say regarding everything he's saying is that he's saying one thing over and over and expecting a different result. And what is that thing? Asking that the Supreme Court should relitigate the matter. It's like you lost a football match and you claimed the weather was the reason and you wanted a replay of the match. Or you lost the match because your defenders were poor. And then you want an opportunity for a replay so you can bring better defenders from the bench. It doesn't work that way. Everything they are talking about, facts in terms of calculating, plus and minus, who scored. It is the duty of a party who goes to court to establish that he has the highest number of lawful votes, and two, that he met the required spread. It is the duty of the party. It is not the duty of the court. If the party fails to establish his court case, the court cannot interfere into the affairs of the party. Secondly, grounds for review are not matters of facts which were considered and comprehensively dealt with by the courts. Grounds for review are errors that the Supreme Court failed to avert its mind when it was giving the judgment. So, and it is from the ground of appeal of an appellant or applicant that you will know if the stating facts plus minus we score, we didn't meet the spread, is dead on arrival. But if it is saying that, like in the case of David Lyon, we are not challenging the disqualification. It is proper. It is a law. But having disqualified, there is a provision in the Electoral Act that provides for a relief like that. Section 140 sub 2. That section of the law, it is the key that preserves the sanctity and inviolability of the voters. It is that section that preserves the right of voters. That if you find that somebody has been nullified because he's not qualified, because qualification does not delve on the substance of the vote. Qualification are technical issues. The whole gamut of election is to determine who scores the highest vote. So if you disqualify someone on the ground of qualification, then 140 sub 2 applies. That you cannot declare the person who scored the second highest vote as the winner, like they did in the case of David Lyon. So David Lyon can come to the Supreme Court and ask for a review, that the Supreme Court reached that decision in error. Because at the time the Supreme Court gave the decision, Supreme Court did not avert its mind to section 140 sub 2. And therefore, the proper order in the circumstances would have been to declare fresh election. Worst case scenario, let me tell you something, Sean. Please permit me to say this. The Supreme Court is a court of wisdom. It's a court that gives no room for speculation in its judgment. In Yari's case, they not only disqualified the party and the candidate, they proceeded to expressly state that the vote cast for him were wasted votes. In the case of David Lyon, they disqualified him, but they did not make mention of the vote as wasted votes. It gives no room for INEC or whoever to interpret. In any case, if you have a doubt, all you can do is to approach the court again for interpretation, which does not fall within the purview of INEC.
Okay.
What ought to have been done after the judgment would have been for INEC or the Attorney General of the Federation to advise that the speaker in that House of Assembly be elected pending the resolution of the dispute, because the court did not void the vote. The court is always expressed to say the votes are wasted. In this case, the court never said that.
We need to close now. Let me give you 10 seconds for your final thought.
Yeah, he just said that in the case of Lion, that the Supreme Court did not advert its mind to section 141 of the Electoral Act. We're saying the same thing. In like manner, In the case of Hope Uzodinma and Ihedioha, the Supreme Court did not avert its mind to Section 179 of the Constitution, which talks about the spread, Section 179, subsection 2B, which talks about the required spread. And that is what it is.
All right. We need to leave it at that. But before we go, let me get some of your views on the program tonight. Some of the tweets coming. Kawadi Son at Busi IKK says, the denial of current realities by the spokesperson of Buhari government lent credence to the fact that there is a disconnect between the government and citizenry. The precarious security situation demands a new approach. Yusuf Adebanjo says, it seems to me that our politics is becoming over-judicialized with VAR in court, rulings with a seemingly consequential subversion of the people's will. Our judiciary too is seemingly becoming politicized. In a fledgling democracy, a balance has to be struck. Those are some of your views. I must sincerely thank my guests tonight, Mr. Ofeli and Mr. Daniel Buala.